Good afternoon, please be seated. The sitting is now open. The court meets this afternoon to hear Antigua and Barbuda, Saudi Arabia, Australia, the Bahamas, Bangladesh, and Barbados on the questions submitted by the United Nations General Assembly. Each of the delegations has been allocated 30 minutes for its presentation. The court will observe a short break after Australia's presentation. I shall now give the floor to the delegation of Antigua and Barbuda. I call His Excellency Gaston Brown to the podium. Your Excellency, you have the floor.
Mr. President, members of the court, I appear before you to speak on behalf of the people of Antigua and Barbuda, a small island state on the front line of a global climate emergency. We come to you because existing action has not adequately addressed the crisis that is devastating our lives and our future. For decades, Antigua and Barbuda has experienced the grave consequences of climate change. Rising sea levels, driven by the unchecked emissions of greenhouse gases, have eroded our coastlines, swallowing land that is vital to our country. Ocean temperatures have risen, disrupting the delicate ecosystems that sustain our fisheries, an essential source of food and livelihoods. More frequent and intense weather events have destroyed homes, decimated infrastructure, and left scars in the lives of our people that no amount of financial aid can truly heal. Hurricane Irma in 2017 was a turning point for our nation. The island of Barbuda is 62 square miles. Irma, the largest recorded storm in the Atlantic at that time, was 375 miles wide when it thundered over the island with ferocious winds of 220 miles per hour. Barbuda clearly did not stand a chance. If we were not a single state, the people of Barbuda would have had to literally seek refuge elsewhere. They would have become climate refugees. My government for years sustained the livelihood of the people and rebuilt Barbuda at an immense cost, adding significantly to our debt burden. While large, wealthy countries can borrow on their capital markets at 3% per annum, the so-called high-income SIDS like Antigua and Barbuda must borrow commercially at 10% to finance repeated rebuilding of infrastructure damaged by hurricanes caused by the failure of other states to mitigate emissions. Mr. President, the principle of prevention, a cornerstone of international environmental law, demands that states take action to avoid causing significant harm to others. Yet, global emissions continue to rise. As the threshold of 1.5 degrees Celsius is being crossed, the very existence of our small island states is threatened by this failure of polluting countries to act. No participant has disputed that greenhouse gas emissions emanating from human activity are causing and will continue to cause significant harm to the climate system, to populations globally, and to the environment. Nor does any participant dispute the conclusion of the global stocktake that current efforts are insufficient. Even now, the Loss and Damage Fund, which was recently established, has received only $700 million in pledges, and I emphasize pledges, not contributions. This pledge amount is wholly inadequate compared to the scale of climate-related losses our small countries are suffering. Antigua and Barbuda has worked tirelessly to address this crisis. At every conference of the parties, from Paris to Baku, we have joined with other vulnerable nations to demand action, to demand financing, and to demand justice. That advocacy has taken us to fora outside of the UNFCCC, to the UNGA, to ITLAS, and to creating the Commission of Small Island States and Climate Change and International Law courses. We seek this advisory opinion not to point fingers, but to clarify the obligations of states under international law before the clock on our survival runs out. We ask, what must small states or states generally do under international law to protect the climate system for present and future generations? What is the responsibility of those whose actions have contributed disproportionately to this crisis? Antigua and Barbuda stands in solidarity with other vulnerable nations, particularly our fellow small island states. Together, we endure the worst of a crisis that we did not create. But today, we also stand with the millions across the globe who are looking to this court for a path forward, for clarity, for justice, and certainly hope. We believe in the power of international law to bring about change. This court's voice can inspire the urgent action that has eluded the political arena. It can remind the world that the rights of small nations, of vulnerable peoples, and of future generations are not secondary, but fundamental. The people of Antigua and Barbuda are counting on you. The world is counting on you. And I state here that this is not just a legal question. It is a matter of survival. Mr. President, I ask that you now call on Mr. Phillips, who will address the legal points. Thank you.
Gaston Brownie, I now give the floor to Mr. Phillips. You have the floor, sir.
Mr. President, members of the court, in order to assist the court, Antigua and Barbuda will address a select number of points. I begin with the Paris Agreement. The scale of the climate crisis was known as long ago as the 1960s. In a collective effort to combat climate change, states agreed on the climate treaties, most recently the Paris Agreement in 2015. Today, however, many high-emitting states attempt to rely on the climate treaties as a shield to escape accountability. Their approach to the Paris Agreement would deprive the most vulnerable of any redress. First, these states argue, in effect, that the obligations of the Paris Agreement are merely procedural. In other words, so long as a state ticks the box to identify a nationally determined contribution, or NDC, it has complied with Article 4 of the agreement. For these states, this is so even if both the ambition and the implementation of the NDC fall manifestly short of a meaningful contribution to ensuring that temperatures do not rise above 1.5 degrees. Second, certain of these states simultaneously argue that either the Paris Agreement displaces all other relevant rules of international law, including the customary obligation of prevention, or that compliance with Paris translates automatically to compliance with those other rules. These two arguments together would lead to a surprising conclusion that the climate change treaties leave the world and the most vulnerable states therein less well protected than if these treaties had never been concluded. This is a dangerously regressive approach. It is also erroneous for the following reasons. First, NDCs are not empty decorations. Under Article 4, each state must set its proposed contribution to a level corresponding to a fair share of remaining carbon budget to meet the 1.5 degree temperature goal. And they must take all measures at their disposal to achieve their proposed contribution. This understanding is further corroborated by a COP decision obliging parties to explain in writing how their NDC is both fair and ambitious in light of national circumstances, and how it contributes to the Paris temperature goal. Second, The customary obligation of prevention remains in any event applicable along with other treaty-related obligations. As the Chamber of the ICJ recognized in the LC case, the Court must not accept that an important principle of customary international law should be held to have been tacitly dispensed with in the absence of any words making a clear intention to do so. There is no evidence that the states in the climate treaties themselves or in their contemporaneous or subsequent practice intended to dispense with the existing legal protections. To the contrary, the UNFCCC confirms the continued relevance of both custom and treaty-based regimes. The climate treaties and other sources of law mutually reinforce and shed light on one another. Compliance with the Paris Agreement is necessary, but may not be sufficient for compliance with states' obligations under custom, UNCLOS, and human rights institutions. Antigua and Barbuda therefore agrees with the dozens of other participants in these proceedings and the European Court of Human Rights and the ITLOS that Paris Agreement does not displace and instead operates harmoniously with the customary obligation of prevention and other relevant rules of international law. I turn now to the obligation of prevention. The attempt by a handful of participants to render this customary rule inapplicable is unconvincing. First, high-emitting states consistently attempt to distinguish between conventional transboundary harm, to which the obligation of prevention applies, and harm occasioned by the climate crisis, to which allegedly it does not. This contrived distinction has no basis in law or in fact. The large-scale nature of the transboundary environmental crisis does not carry it beyond the scope of international law. To the contrary, the protections of international law apply with added rigor. Second, some states attempt to argue that applying the obligation of prevention to climate change would require the emergence of new customary rules. This is wrong as a matter of law. It confuses the existence of a norm with its application to a given set of facts. There is no doubt that the general obligation to prevent significant transboundary harm exists in custom. International courts and tribunals can and must apply that norm when presented with specific facts. States have not excluded the application of existing customary norm to the climate change. To the contrary, climate treaties explicitly affirm the ongoing applicability of customary obligations. As to the content of the obligation, because high-emitting states have not acted and are not acting with the appropriate diligence in light of the nature of the risk and their capabilities and responsibilities, I will touch briefly on these elements. The severity of the risk cannot be overstated. With each successive IPCC report, our understanding of the magnitude of the risk has increased. We also know with scientific precision that the remaining carbon budget available to keep global warming under 1.5 degrees and the harms that will occur failing that. There is, in the IPCC's words, a rapidly closing window of opportunity to avoid catastrophic damage. The standard of diligence applicable to high-emitting states in this context is, in the words of ITLOS, stringent. Allocating a greater burden of emission reductions to high-emitting developed states is inherent in the notion of due diligence obligation. The Court has already accepted that the level of required diligence is premised on each state's capabilities. In the context of climate change, the level of required diligence is also differentiated based on each state's responsibilities. And this flows from the principle of CBDR-RC. The argument of certain high-emitting states that CBDR-RC has no role outside the climate treaties is plainly wrong. The UNFCCC requires its parties to be guided by the principle of CBDR-RC in their actions both to achieve the Convention's objectives as well as to implement the provisions of the Convention. As a result, when states take action to achieve climate objectives, they must respect the principle of CBDR-RC, including when they are acting under the prevention obligation and human rights obligations. The European Court of Human Rights recently confirmed this interpretation. Seeking a harmonious interpretation across legal regimes, the European Court relied on the principle of CBDR-RC outside the climate treaties, specifically in the context of states' due diligence. States' due diligence obligations to mitigate greenhouse gas emissions from their international human rights obligations. Taking these elements together, the obligations of states are clear. To act with diligence, states must make rapid, deep, and sustained cuts to national greenhouse gas emissions in light of the remaining carbon budget. They must do so taking into account the evolving level of risk and their respective capabilities and responsibilities. The IPCC, which produces the best available science, also stressed the importance of carbon budgets and identified the remaining budgets for keeping within the 1.5-degree limit, as each state must use not more than an equitable share thereof, with developed states taking the lead. It necessarily follows that, firstly, a developed state must do its utmost, using all means at its disposal, to reduce its emissions considerably more than 43% by 2030, 60% by 2035, 69% by 2040, and 84% by 2080 compared with 2019 levels. To achieve a net zero CO2 emissions well before 2050 and net zero greenhouse gas emissions well before early 2070. Second, a developing country must still contribute, but its equitable share may be less demanding depending on the past and present emissions and the level of development and capabilities. Some states emphasize that there is yet no internationally agreed equitable share of the carbon budget, but we say this is not an excuse. The absence of an agreed methodology for apportioning shares simply means that there is a corresponding obligation to cooperate to reach that agreement. In the absence of an agreement, a diligent state must develop its own methodology to determine its equitable share using the best available science in good faith recognition of its own capabilities and responsibilities. Moving to the second question, state responsibility. All participants accept two principles. First, a breach of international obligation automatically gives rise to state responsibility. And second, the content of that responsibility, namely the state's duty to make reparation, depends on the existence of harm and a causal nexus between the breach and the harm. The application of the second principle in the case of climate change, however, is where some participants differ. While the harm caused by climate change is well established, some participants argue that the necessary causal link cannot be proved. They contend that the causal complexity makes it impossible for an obligation to make reparation to arise in respect of a wrongful emission. In other words, they ask the court to sanction a situation of breach with no responsibility to make reparation for it. That would be, in the language of the Trail Smelter Award, a perversion of fundamental principles of justice to deny all relief to the injured person and thereby relieve the wrongdoer from making any amend from his acts. When the court has been faced with similar arguments, it has consistently rejected them. It has first reaffirmed that even though the state of science regarding the causal link between the wrongful act and the damage may be uncertain, that will not automatically preclude the existence of a duty to make reparation. Second, it has identified principles to accommodate uncertainties in assessing the existence, extent, and cause of harm. The court should affirm this approach in this present case. It is useful to examine how causation is accommodated in the rules governing existence, content, and extent of state responsibility. As a first step, determining the existence of an internationally wrongful act requires that conduct constitutes a breach of an international obligation which is attributable to the state. For the obligation of prevention, a state must have failed to use all means at its disposal to prevent emissions emanating from within its territory or subject to its jurisdiction from resulting in significant harm to the environment. The court has confirmed that causation does not play a key role in determining a breach of this type of obligation. States are under a duty to act, which is not dependent on the certainty that the action taken will succeed in preventing the relevant harm, or even has a likelihood of doing so. On this basis, both the ITLOS and the European Court of Human Rights have rejected the so-called drop-in-the-ocean argument that no state can have breached due diligence obligations in the context of climate change because no single state's emissions reductions measures could make a meaningful difference in this crisis. The second step is to identify the content of state responsibility. There will be a duty to make reparation where there is first, injury, and second, a causal relationship between the wrongful act and the injury. Both conditions are capable of being fulfilled in the context of climate change. First, the existence of the injury is axiomatic. In these proceedings alone, scores of states will describe the injury that they have and continue to be suffering. For some small island states, injury rises to the level of compromising their continued existence. Second, the causal link between the wrongful conduct and harm is capable of being satisfied in individual cases. This is because it is scientifically possible to determine a state's contribution to global warming, and because principles exist to address remaining areas of causal uncertainty. This includes the flexibility of the applicable causal standard. The court has affirmed that causation must be sufficiently direct and certain, with sufficiently being a relative concept that takes into account the particular circumstances. Indeed, in the armed activities case, the court confirmed that the causal nexus required may vary depending on the primary rule violated and the nature and extent of the injury. The court should confirm that approach in this present case. As an illustration of this flexible standard, in armed activities, the court adopted a presumption of causation. It held that it was for the breaching state to establish that a particular injury was not caused by its failure to act within the diligence to prevent certain conduct of individuals within its territorial control. The same presumption applies by analogy in respect of wrongful emissions from a state's territory that are clearly contributing to the climate change harm. This would be complementary to the scientific proof of causal connections between specific states' emissions and harm, and could be one way to address remaining causal uncertainties. A number of participants argue to the contrary, that it is not scientifically possible to satisfy the causal link between a state's wrongful emissions and harms sustained so that a duty to make reparation would arise. These states are wrong, but they are also asking the court to find, as I have already noted, that states may be responsible for breaches of international law, but that there will be no obligation to make reparation. This would prejudge or even prevent the commencement of future cases. To ask the court to go to such lengths is remarkable. What these states are primarily concerned about is being held responsible for more than their fair share in a situation where there are concurrent causes of harm. but that concerns the extent of the duty to make reparations, not whether that duty exists at all. As the court has held, the fact that damage was the result of a concurrent causes is not sufficient to exempt a responsible state from any obligation to make reparations. The third step concerns the extent of responsibility. International law has mechanisms that deal with apportionment of the duty to make reparations across multiple states. The armed activities case, again, is instructive. The court confirmed that in certain cases where multiple causes result in an injury, responsibility for part of such injury should instead be allocated among those actors or causes. These principles, supported by scientific techniques, allow the court to best approximate the relevant state's share of responsibility in light of contributing factors. In sum, causal complexity in the context of climate change is no bar to the existence, content, or extent of state responsibility, including a duty to make reparations. Antigua and Barbuda respectfully urges the courts to give particular credence to the views of small island developing states, especially affected states, on the applicability of the duty to make reparations in the context of the climate change crisis. Mr. President, members of the court, Antigua and Barbuda thanks you for your time.
I thank the representatives of Antigua and Barbuda for their presentation. I now invite the next participating delegation, Saudi Arabia, to address the court, and I call upon His Highness Prince Jalawi Turki Al Saud to take the floor.
Bismillah ar-Rahman ar-Rahim. Mr. President, members of the court, it's a great honor to appear before you in these important proceedings and to do so on behalf of the Kingdom of Saudi Arabia. As a country particularly vulnerable to extreme heat, weather scarcity, desertification, and other adverse effects of climate change, the Kingdom acknowledges the urgency of taking action to mitigate the harmful effects of climate change. As a state with a resource-dependent economy, economic diversification objectives, and historically low greenhouse gas emissions, the Kingdom emphasizes the importance of international cooperation to advance global efforts to protect the climate system by addressing anthropogenic greenhouse gas emissions. At the same time, efforts to address greenhouse gas emissions must occur alongside efforts to ensure the fulfillment of the objectives such as energy security, energy affordability, poverty eradication, food security, and economic development, among other goals, in order to achieve sustainable development. Peoples around the world have historically had unequal access to energy and have made unequal contributions to atmospheric greenhouse gas concentrations. Those states that participated in the Industrial Revolution early on enjoyed advantages in welfare, infrastructure, and economic development. Having regard to state differentiated responsibilities and capacities requires recognition of different starting points, development needs, and social context. The response will not be uniform across countries and regions. The Specialized Treaty Regime on Climate Change, comprised of the United Nations Framework Convention on Climate Change, the Kyoto Protocol, and the Paris Agreement, address these complexities. Under the Specialized Treaty Regime, the Kingdom actively participated in negotiations and contributes to the response of climate change. The Kingdom's response includes nationally determined contribution, as well as several ambitious initiatives such as the Saudi Green Initiative and the Middle East Green Initiative. Additional details on the Kingdom's efforts and initiatives are in our written statement. Mr. President, allow me to highlight 3 important points. First, the Specialized Treaty Regime on Climate Change provides a complete answer to the question on obligation and consequences. Second, the Specialized Treaty Regime on Climate Change is a remarkable achievement. It is specifically designed to address the complex global phenomenon on climate change. It was reached through determined and rigorous negotiations and guided by the multilaterally agreed principles. The treaty regime reflects the good faith efforts of all participating states to reach pragmatic and effective agreement on what are immensely complex policy matters for every state. Third, to impose any obligations or consequences that go beyond or conflict with those contained in the specialized treaty regime on climate change would risk undermining the integrity of this regime and impaired future progress in international efforts to protect the climate system. Mr. President, our next speaker will be Sir Michael Wood, who will address you on the role of the court and the applied law. He will be followed by Ms. Ghaida Bajaba from the Saudi Ministry of Energy, who will speak to the application of the two questions put by the General Assembly. Mr. President, members of the court, I thank you for your attention. I request that you invite Sir Michael Wood to the podium.
I thank His Highness Prince Jalawi Turki Al Saud. I now give the floor to Sir Michael Wood.
Mr. President, members of the Court, it's an honour to appear before you and to do so on behalf of the Kingdom of Saudi Arabia. In the time available, I must be selective. We maintain and attach importance to all the points in our written statement and written comments. The fact that we do not cover certain points made by others does not mean that the Kingdom agrees with all that they say. Mr. President, I shall address the Court's role in these proceedings, as well as the applicable law. We urge the Court to adopt a cautious approach when answering the two questions posed by the General Assembly. The need for caution was addressed in the General Assembly debate upon the adoption of Resolution 77-276, when many states emphasised that it was not for the Court to impose additional obligations or responsibilities on states. The consensus among states at the General Assembly was based on a clear understanding of the role of the Court and the scope of the questions. Mr. President, members of the Court's role in advisory proceedings, as in all of its work, is to apply the lex lata. This is particularly so given ongoing negotiations among states pursuant to the specialised treaty regime on climate change to further advance global efforts to protect the climate system by addressing anthropogenic greenhouse gas emissions, negotiations which are based on state sovereignty and on consent. Despite some calls that seem to be urging the Court to impose new obligations, advisory proceedings cannot be a substitute for negotiation. An effective and progressive response to the threat of climate change requires active and good faith negotiation and cooperation among states based on states' own policy choices and on their consent. Such choices are not matters that courts can impose from above. The specialised treaty regime on climate change contains a well-established framework that governs states' negotiation and cooperation, providing the Court with the basis for addressing the questions before it. This regime establishes a legitimate mechanism for stabilising greenhouse gas concentrations in the atmosphere, precisely because it is based on the clear consent of states. A judicial response that departs from the lex lata and alters the specialised treaty regime on climate change would undermine the credibility and effectiveness of the existing legal regime and the framework for negotiation, cooperation and consent that the treaties establish. Mr. President, members of the Court, the chapeau added by the General Assembly to the questions in Resolution 77-276 lists a series of instruments, duties, rights and principles, some applicable, some not. In any event, it is not for the General Assembly to determine what law is applicable to answering the questions put to the Court. The chapeau cannot have an effect on the Court's function of determining the applicable law. In the recent Occupied Palestinian Territory opinion, after setting out a rather similar chapeau, the Court went on to make clear that, and I quote, "The Court will determine which rules of international law are relevant for answering the questions posed by the General Assembly." End quote. Jura novit curia. It is for the Court to determine the applicable law. I now turn to the applicable law that is relevant to the questions put by the General Assembly. All participants accept that, under international law, states' climate change obligations are primarily governed by the specialised treaty regime on climate change. It is fundamental that the Court reaffirms the primacy of this specialised treaty regime, since it reflects the consensus of states on how to address the global threat of climate change. Some, however, seem to be suggesting that it is the scientists that determine states' legal obligations. That is not so. It is the treaties, not scientists, that set out legal obligations. One other important point that I should make is the coherence of the specialised treaty regime. Contrary to certain suggestions, the Kyoto Protocol, the Paris Agreement, and other instruments and measures developed exclusively under the UNFCCC enhance the implementation of the UNFCCC and build upon the principles and provisions established in the UNFCCC. Mr. President, members of the Court, that concludes my short statement, and I request that you now invite Ms. Ghaida Bajba to the podium. I thank you, Mr. President.
I thank Sir Michael Wood. I now give the floor to Ms. Ghaida Bajba. Madam, you have the floor.
Mr. President, members of the Court, my name is Ghaida Bajba from the Ministry of Energy. It's a great honor to address you and to do so on behalf of the Kingdom of Saudi Arabia. In response to question A, I shall first address certain aspects of the specialized treaty regime on climate change. The importance of nationally determined contributions, NDCs, certain fundamental principles of the treaty regime and its primacy. I shall then say a word about the interpretation of the specialized treaty regime, which cannot be expanded by reference to other instruments. And finally, I should offer some thoughts on question B. Mr. President, members of the Court, the Kingdom and other participants have described in detail in their written pleadings the specialized treaty regime on climate change. Among other things, all states have a binding obligations to prepare, communicate, and maintain their NDCs, taking into account common but differentiated responsibilities and respective capabilities and national circumstances. While the NDC process is mandatory, the content, implementation, and achievement of the NDCs themselves are not legally binding. States have full discretion to determine their NDCs. That is intentional. That deliberate choice for voluntary contributions by states is central to a proper understanding of states' obligations, referred to in the questions before the Court. NDCs concern an obligation of best efforts, not of result. The specialized treaty regime on climate change is based upon certain fundamental principles. I only have time to mention two and refer you to the Kingdom's written pleadings for further details. First, the principle of common but differentiated responsibilities and respective capabilities. As is universally recognized, the atmospheric concentrations of greenhouse gases contributing to climate change date back to emissions from the Industrial Revolution. This historic responsibility is recognized in the treaty regime. Second, the treaty regime emphasizes stabilizing atmospheric greenhouse gas concentration in a time frame that expressly enables economic development to proceed in a sustainable manner and on the basis of equity and in the context of sustainable development efforts to eradicate poverty. These principles are the bedrock of the treaty regime, essential for many states to be able to join the negotiating consensus. It is important that they are clearly affirmed in the Court's opinion. The Kingdom believes there is no room to play down the primacy of the specialized treaty regime on climate change and overlook the crucial importance of the worldwide acceptance of the regime. The Paris Agreement's requirement for the parties to identify and maintain indices is a carefully designed mechanism for advancing progress towards the Paris goals. Almost every state has submitted an NDC. This is a significant achievement. The specialized treaty regime on climate change provides no basis for the Court to recommend limits on fossil fuel extraction and production. No basis whatsoever. The specialized treaty regime requires parties to consider actions necessary to meet the specific needs and concerns of states not listed in Annex 1 to the UNFCCC and affected by response measure to climate change, including those with economies highly dependent on fossil fuel production and export. Failure to respect these provisions would undermine the carefully negotiated balance under the specialized treaty regime that accommodates the diverse economic circumstances of all parties. Perhaps most critically, the Court should not interrupt the treaties in a way that goes beyond what was agreed by the negotiating states. This is particularly so with respect to aspirational provisions, such as the temperature goals in Article 2 of Paris Agreement, which do not impose legally binding obligations. Some participants argue that scientists should determine states' obligation. That, with respect, cannot be the case. As stated previously, it is the treaties that set the obligations. Nothing would threaten future progress in international effort to protect the climate system more than distorting and misrepresenting agreed language. Apart from the specialized treaty regime, none of the treaties or instruments mentioned in the chapeau to the questions was intended to address climate change. These instruments were not designed to address the unique challenges presented by the climate change. This is the case in the Law of the Sea Convention, which has been considered by states in the context of the advisory proceedings in Hamburg. We set out at some length our considered positions on ATLAS advisory opinion in our written comments. In short, the law of the sea cannot be interpreted as imposing obligations that are inconsistent with or go beyond those agreed in the specialized treaty regime. Mr. President, members of the Court, the principle of international environmental law and international human rights law referenced in the chapeau were not developed in the context of climate change or agreed by states in the specialized treaty regime. They are not applicable to the questions before the Court. nor can the application of notions such as harmonization or systematic integration serve as basis for imposing wholly new or inconsistent obligations on states with respect to climate change. The no-harm principle was not designed to apply to the protection of the climate system from greenhouse gas emissions, nor does it do so. It concerns transboundary environmental damage caused directly by activities in the territory of one state to the territory of a neighboring state. As several participants have observed in their written pleadings, the no-harm principle applies in a bilateral context where there is a clear link between the source of harm and the affected state. The principle doesn't apply whereas here, anthropogenic climate change results from a whole range of varied and diffuse activities and events that emit greenhouse gases accumulating over a long period of time. Some participants have referred to a right to a safe, clean, healthy and sustainable environment. But as we and others have explained, such a right hasn't entered the corpus of international law, and the implications flowing from any such right haven't been spelled out and agreed. The obligations under human rights treaties also do not address the protection of the climate system from anthropogenic greenhouse gas emissions. It is important to note that international human rights obligations apply only to the states parties to the particular treaty, and then only in respect to individuals in their territory or under their jurisdiction. The statements of human rights bodies and special rapporteur do not affect this position. As the court recalled in the Qatar versus United Arab Emirates case in connection with the Human Rights Convention, and I quote, "The interpretation must be based above all on the text of the treaty." End of the quote. Decisions of regional or domestic courts and tribunals are not source of general international law. There are many reasons for this, primarily, of course, because national or regional courts are usually applying national or regional law, including domestic constitutional law or regional human rights law. Even when they seek to apply public international law, they may do so through a domestic or regional lens. Mr. President, members of the court, I now turn to question B. Like question A, question B doesn't ask the court to seek to qualify the activities that resulted in emissions. It was clear when the questions were asked that there were no intention for the court to consider the responsibility or liability of individual states. As we and others have explained in our written pleadings, the climate change treaty regime contains its own compliance mechanism to deal with the legal consequences where a significant harm is caused. In addition to mitigation and adaptation requirements, the treaty regime contains a loss and damage mechanism which seeks to deal with cases of harm. Mr. President, members of the court, as you are aware, a loss and damage fund has already been established. Where a party considers that another party has breached its obligation, it may invoke the relevant compliance and dispute settlement mechanisms, including under Article 15 of the Paris Agreement. This provision establishes a mechanism to facilitate implementation of and promote compliance with the Paris Agreement. Some argue for application of the residual rules of customary international law on state responsibility, as proposed by International Law Commission. However, as many participants have recognized in their written pleadings, there are significant problems with applying these residual rules in the present context. Above all, there are highly problematic questions of causation. In any event, Article 55 of the Articles on State Responsibility provides that they do not apply where and to the extent that the conditions for the existence of an internationally wrongful act or the content or implementation of the international responsibility of a state are governed by special rules of international law. The specialized treaty regime on climate change itself determines the legal consequences of significant harm to the climate system. Finally, with respect to point 2 in question B, the specialized treaty regime doesn't, The specialized treaty The specialized treaty regime doesn't confer rights upon individuals. Moreover, as others have also made clear, the concept of peoples and individuals of future generations is too indeterminate for them to have legal status or standing or for claims to be made on their behalf. Mr. President, I would like to conclude with 3 points. First, the Kingdom of Saudi Arabia respectfully requests the Court to answer questions A and B by confirming that state obligations to protect the climate system and other parts of the environment from anthropogenic greenhouse gas emissions are those set out in the specialized treaty regime on climate change. And the legal consequences under the obligations are to be determined by reference to the specialized treaty regime on climate change. Second, determining obligations that are inconsistent with or go beyond those agreed in the specialized treaty regime would undermine the ongoing and future progress in international efforts to protect the climate system. Third, to strengthen the global response to the threat of climate change, the Kingdom is committed to the full implementation of the principles and obligations embodied in the specialized treaty regime, UNFCCC, the Kyoto Protocol, and Paris Agreement. Mr. President, members of the Court, that concludes the oral presentation of the Kingdom of Saudi Arabia. We thank you for your attention. I thank you, Mr. President.
I thank the representatives of Saudi Arabia for their presentation. I now give the delegation of Australia to invite the delegation of Australia to address the Court, and I give the floor to Mr. Jesse Clark.
Mr. President, Madam Vice President, distinguished members of the Court, it is a great honour to appear before you on behalf of Australia. Climate change is one of the defining challenges of our time. Australia is resolutely committed to taking urgent action to address the effects of anthropogenic greenhouse gas emissions on the climate system. In that context, Australia was proud to co-sponsor the United Nations General Assembly resolution requesting an advisory opinion from this Court. Climate change is the greatest shared threat to all countries. It is having significant impacts, in particular on small island states, and these impacts will only increase as the temperature of the planet rises. Indeed, climate change poses the single greatest threat to the livelihoods, security and well-being of the peoples of small island states, including Pacific island states. Australia commends the long-standing leadership of our Pacific neighbours in shaping global responses to climate change and, in particular, Vanuatu's leadership in driving forward the request for this advisory opinion, together with the core group. Australia is committed to working with the Pacific to strengthen the global responses to climate change. Global cooperation is critical to delivering an effective response to climate change. Australia acknowledges the extent of the challenge posed by climate change and recognises that ambitious individual and collective action must be undertaken urgently. In this regard, the UNFCCC and the Paris Agreement are the central instruments that provide the framework for international cooperation and commitments to tackle the grave challenge of climate change. Collective action under these treaties has resulted in a reduction over time of projected future levels of greenhouse gas emissions. However, parties are not yet on track to ensure the objective of the UNFCCC and the goals of the Paris Agreement are met. Australia recognises there is an urgent need for states to take stronger individual action now to achieve our collective goals, which is even more pronounced today than it was in 1992. Unless greenhouse gas emissions peak and rapidly reduce in the near term, we will experience rapid warming and more pronounced changes to sea levels, river flow, water temperature and precipitation. To maximise the chance of meeting the temperature goals of the Paris Agreement, the world's largest emitters, which have not yet peaked and begun to reduce their emissions, must rapidly do so. Australia is taking urgent and ambitious climate action to reduce greenhouse gas emissions, decarbonise its economy, strengthen national and regional adaptation, and increase resilience to the impacts of climate change. Australia is resolutely committed to achieving the objective of the UNFCCC and the goals of the Paris Agreement, including by strengthening its emissions reduction targets, legislating a commitment to achieve net zero by 2050, and delivering on its climate finance commitments. The questions before you provide an important opportunity for the Court to clarify the existing legal obligations of all states and the particular legal consequences for all states with respect to climate change. The Court has not been asked to opine on the international responsibility of or consequences for any specific state or group of states. In particular, question B does not require or invite the Court to determine whether breaches of any such obligations have occurred or will occur, nor whether particular states are specially affected or injured. Australia observes that there are many areas of consensus among the participants to these proceedings. In particular, there is broad agreement on the competence of the Court to render an advisory opinion in this matter, the central role played by the UNFCCC and the Paris Agreement in setting out states' obligations to address climate change, and the need to address the complex challenges of climate change on the basis of best available science, as most recently reflected in the 6th report of the Intergovernmental Panel on Climate Change. Australia was also pleased to see strong consensus on the need for international cooperation and increased ambition in collective responses to climate change. By way of outline, the Solicitor General of Australia will address the UNFCCC and the Paris Agreement and the relevance of customary international law and the United Nations Convention on the Law of the Sea. Dr. Parlett will address you on question B as regards legal consequences. I thank the Court and, Mr. President, request that you now pass the floor to the Solicitor General.
I thank Mr. Clark. I now give the floor to Mr. Stephen Donny. Sir, you have the floor.
Mr. President, Madam Vice President, distinguished members of the Court, It's a great honour to appear before you again on behalf of Australia. There is broad consensus amongst the participants in these proceedings on the central role of the UNFCCC and the Paris Agreement to the questions before the Court. The preambular language to both treaties describes climate change as a common concern of humankind, and consistently with that statement, these two treaties have near universal participation. They are the primary source of states' obligation under international law in respect of climate change, setting out both collective goals and aims alongside individual obligations and commitments. They create the central cooperative framework for the collective action that is needed to address both the causes and the impacts of climate change. The first global stocktake under the Paris Agreement showed that parties have made significant progress but are not currently on track to achieve the goals of the Paris Agreement. Importantly, however, the Paris Agreement has built-in mechanisms to address this, because each party must set an NDC every 5 years, which represents a progression beyond its last NDC, is informed by the outcome of the global stocktake, and which reflects the state's highest possible ambition. The global stocktake sets out clear next steps to address the gaps in climate ambition and implementation, including first, encouraging parties to set ambitious next NDCs that are economy-wide, cover all gases and sectors, and are aligned with limiting global warming to 1.5 degrees, as informed by the latest science. And second, setting new collective energy efforts to triple renewable energy capacity and double the annual rate of energy efficiency improvements by 2030, and to transition away from fossil fuels in our energy systems. The outcomes of the global stocktake demonstrate the dynamic process the climate change treaty regime creates for assessing progress and for adjusting action over time. The differentiated obligations of parties to the UNFCCC and the Paris Agreements, and the capacity of those obligations to adjust in light of parties' evolving national circumstances, and as best available science continues to inform the steps required to respond to climate change, underlies their status as the primary source of relevant legal obligations. Australia recognises that other treaties contain obligations that are relevant to the protection of the climate system, or that play an important complementary role alongside the climate change treaties. These include UNCLOS, international environmental treaties, sector-specific agreements that address specific types of anthropogenic greenhouse gas emissions, and international human rights treaties. Australia also recognises that the duty to cooperate under customary international environmental law is applicable to states' actions to address climate change. In respect of the relationship between the climate change treaties and other areas of law, Australia makes two observations. First, contrary to the submissions of some participants, it is not necessary for the Court to have regard to the rule of lex specialis, which is primarily focused on the resolution of normative conflicts in relation to the complementary obligations that exist under international law for the protection of the climate system. Second, this Court should promote a harmonious interpretation of states' obligations to protect the climate system from greenhouse gas emissions. As such, where other treaties and customary international law also impose obligations relevant to the protection of the climate system from climate change, those obligations must be interpreted consistently with those that have been carefully negotiated and agreed by the vast majority of states under the UNFCCC and the Paris Agreement. In this context, Australia emphasises that the rule reflected in Article 31(3)(c) of the Vienna Convention on the Law of Treaties addresses a situation where rules of international law external to a treaty are relevant to its interpretation, but does not operate to incorporate obligations from one treaty or from customary international law into another treaty. I turn next to the relevance of customary international law. The vast majority of participants, including Australia, recognise that the principle of prevention is a rule of customary international law that applies to significant transboundary harm. There is, however, divergence in relation to whether this principle applies to environmental harm caused by anthropogenic greenhouse gas emissions. Some participants suggest that the principle of prevention is of general application and therefore applies to harm caused by greenhouse gas emissions. Australia respectfully submits that the principle of prevention does not apply to harm of that kind for two reasons. The first reason is that greenhouse gas emissions are materially different from the conventional case of transboundary harm. Yet it is only in the context of those conventional cases that the court has applied the principle of prevention. Those conventional cases involve a direct and temporally proximate cause of environmental harm from an identifiable source spreading from one state to a neighbouring state, such as discharge of pollution into a river or discharges of noxious gases near the borders between states. That was the context in pulp mills, where the court held that a state is obliged to use all the means at its disposal in order to avoid activities which take place in its territory or any area under its jurisdiction, causing significant harm to the environment of another state. More recently, the court again applied the principle of prevention to claims of significant harm to the environment of an adjacent state in construction of a road. In Australia's submission, the unique nature of the mechanism by which greenhouse gas emissions cause harm to the environment provides an important point of distinction from cases of ordinary transboundary harm. Specifically, harm from greenhouse gas emissions arises by reason of the cumulative build-up of greenhouse gases in the atmosphere over a long period of time, being emissions which many different states and countless private actors are responsible. Furthermore, the harm that results is widespread rather than localised and may be experienced in places far removed from the source of emissions that contributed to its occurrence, rather than simply in neighbouring states. That combination of circumstances means that greenhouse gas emissions give rise to novel challenge in applying the requirements of causation of significant harm and in the determination of responsibility for specific impacts. The second reason that the principle of prevention does not apply to harm caused by greenhouse gas emissions is that there is no consistent or widespread state practice or opinio juris to confirm the existence and content of obligations deriving from the principle of prevention in that context. The divergence in views is clear from the views expressed by states participating in this very proceeding. This point is confirmed by the fact that when the international community addressed the obligations of states concerning greenhouse gas emissions through the UNFCCC and the Paris Agreement, it did not incorporate either the substantive or the procedural obligations that the court has found to be derived from the principle of prevention in conventional cases of transboundary harm. Instead, it developed more tailored and adjustable mechanisms to address the greater complexity of greenhouse gas emissions. For these reasons, to extend the principle of prevention to greenhouse gas emissions would not account for the unique features of the global challenge that such emissions pose. Such an extension would also be unsupported by the requisite state practice and opinio juris. Given the widespread adoption of the specialised climate change treaties, customary international law should not be held to have developed in a way that imposes obligations with a different content. If, contrary to our primary submission, the court concludes that the substantive aspect of the principle of prevention does apply to greenhouse gas emissions, compliance would be assessed against a standard of due diligence. That being so, Australia's view, which it shares with several participants in this proceeding, is that the UNFCCC and the Paris Agreement specify what that standard requires for states party to those treaties. Equally, compliance with those treaties will also satisfy the procedural aspect of the principle, such as obligations regarding cooperation and information sharing. As the very purpose of the UNFCCC and the Paris Agreement is to embody the agreements of states as to the measures that are appropriate and necessary to address greenhouse gas emissions and their environmental impacts. Compliance with those agreed measures entails compliance with any customary international law obligations arising from the principle of prevention. Finally, I turn to UNCLOS. The vast majority of participants, including Australia, recognise the relevance of obligations arising under UNCLOS for the protection of the climate system. There is broad consensus that Part 12 of UNCLOS applies to pollution of the marine environment by anthropogenic greenhouse gas emissions, with the consequence that such emissions may enliven a number of obligations under that part. As a framework agreement, UNCLOS in many instances leaves the development of specific rules and standards to competent international organisations and specific sectoral agreements. In the context of climate change, those standards and rules are found in the UNFCCC and the Paris Agreement, to which the vast majority of states that are party to UNCLOS are also party. In those circumstances, Australia submits that Part 12 of UNCLOS should not be interpreted as imposing obligations with respect to greenhouse gas emissions that are inconsistent with or that go beyond the obligations agreed in the specific climate change treaties. Otherwise, the agreements of states to very general obligations in Part 12 of UNCLOS would cut across the more specific agreements of those same states as to how they should individually and collectively address the harm caused to the whole environment, including the marine environment, by greenhouse gas emissions. Australia welcomes the recent ITLOS advisory opinion and the contribution it has made to clarifying the obligations of states to protect and preserve the marine environment from the impacts of climate change. Australia fully participated in those proceedings, and it recognises and respects the important role of small island states, including Pacific Island states, in requesting and obtaining that opinion. Australia wishes to highlight 5 key observations of ITLOS, which are consistent with the views of a number of participants in this proceeding and with the submissions that I have just made concerning UNCLOS. First, that greenhouse gas emissions constitute pollution of the marine environment within the meaning of Article 114 of UNCLOS. Second,